KAZ Radio's lineup. Today we have Maryann Dybiec with us and the Children's Rights Family Advocate. And here is a disclaimer. This legal education show should not be considered legal advice for your personal case. Please call a lawyer or Maryann's office at 216-227-9111. Well, we have none other than Maryann Dybiec back with us on KAZ Radio, a sorely missed, long reunion. We've been waiting for you. How you doing, Maryann?
I'm very happy to be back. Thank you.
Now, tell us, what's been going on, man? I mean, what have you been doing? You've been traveling. You've been all over the D.C. area. You've just been advocating for children and families and the whole 9 yards.
Yeah, for the past, 20-some years now.
Exactly.
Yeah. So I don't go to Washington anymore. I'm more situated in Cuyahoga County now. Surrounding counties a little bit, but still doing the advocating, still going to court with people, still fighting the good fight.
Still fighting the good fight of faith. That's awesome. And you have a guest with you today, and who do we have in our air chair today?
I do have a guest. Her name is Jessica. Last name is...
Jump.
Chump?
Jump.
Jump, not Jump. I'm sorry, I need my glasses to read. Jessica Jump. She works for Bartos & Bartos, LPA. She's been with them for 2 years now. I'm very familiar with Bartos & Bartos. They're a very good law firm, so she comes highly recommended. Jessica, would you like to give out your number in case anybody listening would want to call your office?
Yes, we can be reached at 440-409-0300.
Thank you. And where are you located?
Rocky River. Right.
And by the way, your new offices are beautiful.
Oh, thank you. Yeah, they're a little bit bigger than the Lakewood office.
Yeah, it's in Rocky River near...
the old Westgate Mall near the Westgate Plaza, so right on Center Ridge Road.
And you'll take clients from Cuyahoga County and surrounding areas?
Yes, absolutely. Most of our client base is Cuyahoga County, but we do also work in Lake County and Lorain County, and we do have one attorney that actually will go out to Erie County as well.
Nice.
Yes.
And Jessica's going to answer a few questions for us today. Like I said, this is a legal education show, so we gave her some questions to think about before she came into our office today, or to the studio, sorry. And we're going to talk about juvenile custody today. Juvenile custody meaning if you were never married and you had a child. Those cases go to juvenile court, which a lot of people misunderstand because they think juvenile court is only for children. But there's a difference. There's domestic court for people who have been married who go through divorce. And then there's juvenile court where you haven't been married and you have to go through, you have to make a contract. How would you put it? They need to file for their parental rights, correct? So my first question would be to you today is, in the state of Ohio, if you're not married, who has custody when the baby's born?
Under Ohio law, if the parents aren't married, then the mother is presumed to be the sole residential parent and legal custodian of the child. Essentially, the father does not have any parental rights until he establishes paternity. Like I said, if it's within a marriage, then paternity would be presumed, but if it's not within a marriage, then the presumption does not exist.
So the father has, here's another thing. I get a lot of questions about this. Some fathers think that they have these parental rights because they've signed the birth certificate. Can you speak to that?
No, they don't. Yeah, it's a common misconception. They say I've signed the birth certificate. There's a couple of ways to establish paternity in Ohio. Number one, obviously, as we've already said, it would be that you're married. The second way would be to actually sign an affidavit of paternity in the hospital. That's different from the birth certificate. However, it is legally binding for purposes of child support, and the court will accept it also for parental rights and the allocation of those parental rights and responsibilities. And then the last way is obviously genetic testing. Unfortunately, until you actually go to court, juvenile court specifically, and ask for those parental rights, and even if you establish paternity and you're paying child support, that doesn't mean that you have them. It's not automatic.
Right. It's such a miscommon assumption that gentlemen will call me and say, excuse me, but the baby's mama took off with the kids, and I think I have rights, and I have to tell them, I'm sorry, you don't until you go through court.
Absolutely, you're right.
So it's very important that the gentlemen, especially fathers in this state, know that they need to go to court to establish those rights. And I think they should do it as soon as possible after the baby's born.
Yeah.
Because I've seen a lot of cases, I'm sure you've seen this too, where something happens to mom.
Right.
And who do they go to if something happens to mom, God forbid?
Who would the children go to?
Yeah, what would happen to the child if the father hasn't established his paternity through juvenile court?
Well, unfortunately, a lot of the answers to your questions is it depends. If the dad has a relationship with the child, then it would probably will go to dad. It also depends on what the mother's family wants to do. In a lot of cases, mom's family it helps as a caregiver for the child, and the child will stay with them either way. That's kind of one of those questions that dad really has no standing, legally speaking. However, common practice is that they would go to dad in that case. If something happens, it also depends on what happens. Is it that she just disappears? Is it that she unfortunately passed away? Or does she go to jail? It would depend.
But it would be really good for every father to go out there and get that paperwork.
Yes, absolutely. I know for most people, it's a very sticky situation. Often, even if they're not married, mom and dad are in a relationship when the child is born. That relationship may fall apart eventually, and then they have some sort of informal agreement, and then it works until it doesn't.
Right.
And when it stops working is when dad figures out that he doesn't have any rights. And here we are,
That's
child's
exactly
10 years old,
right.
And they need to go to court and essentially prove and establish that, yes, I've been this child's father for the last 10 years, and I deserve some rights. And as we all know, the court process can take a long time. So I would suggest...
How long does an average case take if you want to establish what they call custody visitation in the juvenile court?
Well, let me say this. The process usually is when dad files, typically speaking, the court, at least in Cuyahoga County Juvenile Court, they'll send you first to mediation to see if the parents can work it out and whether they need to actually litigate the issue. If it can't be worked out in mediation, then it will go up to a magistrate, and the magistrate will typically give an interim order of visitation. So dad should get some kind of interim visitation order.
But not at the mediation hearing.
But not at the
when
mediation.
It gets put over to court.
Exactly.
And he should be knowledgeable enough to ask for one if they're not offering it, right?
Absolutely. Absolutely.
So that should be his first concern is, please give me a temporary order for access to my child.
Yes. From mediation until the first pretrial, when that interim order would go into place, typically you're looking at 6 weeks. The entire process from beginning to end, from filing until the parental rights are allocated, can take as little as 2 months or as long as a few years. It depends on how much the parents want to fight.
So this could go on really for 2 years?
Oh yes, absolutely.
Wow.
If mom and dad can't figure out how to parent their child together, and they have to have the court decide how they are going to do that, and they have to make an order, then it can take a while because the court is going to want some extra things from them. Typically what happens is that we'll assign what's called a guardian ad litem. It's always an attorney. The attorney then, it's the neutral party. They do an investigation, they do home visits, they speak with the child, school records, medical records, etc., etc. Eventually make a recommendation to the court as to what is in the child's best interest. Essentially, it's the child's attorney or child, they advocate for the child's best interest. So there would need to be time for the guardian ad litem to do their investigation. There's also a diagnostic clinic in the juvenile court in Cuyahoga County. They will do a custody evaluation. They'll meet with each of the parents, they'll watch the child interact with each of the parents, and then do a report and recommendation. That takes time. If there are other issues of possible mental health or drug things going on and the parents can't come to an agreement and you've got to take it to trial, it can take a long time to do. It's usually cheaper and better for your child if you can come up with it on your own.
I was in court a couple weeks ago with somebody, and I noticed that the magistrate wanted the 8-year-old child to be in the court with the parents. Is that standard procedure?
No. However, they're moving toward that.
I heard that.
Yes, they are moving toward
I'm
that.
not happy about that.
Going back to what you were explaining about the jurisdiction issues when parents are unmarried in juvenile, you're in juvenile court. Juvenile court obviously has jurisdiction over juvenile delinquencies as well as children and family services cases. The idea with the children and family services cases is that older children, teenagers, be involved in their own court process, but they're also seemingly taking that same idea into private custody matters. It was just presented and really had an open conversation in December of last year is when they really started discussing how the court was going to be approaching that. Well, at the time, what do you mean they?
Who is they? Who had the discussion?
Well, a lot of the magistrates and judges in juvenile court in Cuyahoga County, as well as a lot of the practitioners, the attorneys. Most of the people that practice in juvenile court are familiar with one another, and they're there most of the time.
Yeah. I notice that every time I go, it's the same people.
So there's a symposium at the end of the year that almost everyone that practices in court attends, and at that symposium is when all of those issues were discussed.
Okay, because
presented to us that children may start participating in their own cases.
I was shocked.
Yeah.
Like I said, I went with a client who had an 8-year-old daughter, and as an advocate, I need to sit in the back of the room while the proceedings are going. I'm not allowed to speak in court. I sat next to this little 8-year-old girl and had to hold her to keep her from crying. So that was a big deal to me. I thought, what is going on here? Is this really okay for the children? Because she was devastated.
Yeah.
The little girl. She was 8. I just think that's way too... It was hard on me. I'm sure it's going to be hard on the children. So remember that, parents. If you're going to fight and you're going to have to take your children to court with you, how embarrassing is that going to be and devastating for these children?
Right.
So thanks. We'll go on to the next question. In Ohio, how does non-custodial... Okay, we already talked about that. How do they get access custody? We were talking about the filing fees. Can you talk about the filing fees a little bit? I think we said it was $105.
Yes, it's in juvenile court. It is $105 if you wanted to just do the first application for parental rights and responsibilities. I'll be honest with you, I'm not actually 100% sure what the fees are because they've changed it recently, where you will have to pay more if there's more than one child. The best way to find that out is to call the court. The court's number is 216-443-8400. If you choose the option for the cashier's office, they'll be able to give you some more information as to what you're looking at with filing fees.
Right.
But yeah, they're significant. There's something to be considered.
Right. Okay, I had a case, not in this county, but it shocked me. The judge ordered the mom to turn over the family dog because the little girl wanted it. Now, mom had custody, father now has custody. Did you ever see that happen? Because mom is refusing to turn over the dog. Do you ever see cases like that? Does that happen?
You see it a little bit more in domestic relations when there's mingled property, marital property, and the judge and the magistrate can essentially order whatever they want to with regard to if it's in the child's best interest that the dog live with the child, then they can certainly make that order, and mom could be found in contempt if she's not in compliance with that order. Yeah,
from what she's telling me, she's going to let them throw her in jail before she turns the dog over. But when she called me and told me that, I was shocked. Yeah. I was like, are you serious? I couldn't believe that actually happened. So
sounds like a very contentious case where in a lot of cases like that, then there needs to be a court order for almost everything. Common sense kind of goes out the window.
Yeah. It's a 4-year-long case and dragging out and stones throwing everywhere. Next question. Can you explain what shared parenting is? In the state of Ohio, when they go to do their complaint for the visitation custody, they're either going to get access to their child or shared parenting. Mm-hmm. Could you explain exactly what shared parenting is versus just having access to your child? Okay.
Shared parenting is what most people understand as joint custody. It's just a new term. It's just friendlier and more flowery, I suppose. The shared parenting means that both parents have equal rights. They're on equal footing with regard to access to the child, access to the child's medical records, access to the child's school records. The language is that both parents are residential parent and legal custodian when the child is in their possession. Okay, the only distinction that must be made between the two parents is that the one parent has to be designated residential parent for school purposes, and that's just, whoever they designate, that kid goes to that particular school district, and the school needs to know that, the state needs to know that for allocating taxes per pupil, that kind of thing. So essentially shared parenting is exactly how it sounds. When the access to your child is simply visitation rights. You may not have the same access to school records. You may not have the same access to medical records. You don't have the same rights to participate in the child's life. For example, extracurricular activities, going to parent-teacher conferences. It's you get to spend time with your child at the very least. Now, a lot of even some of the visitation orders will include some extra rights, so it looks a little bit more like shared parenting, but there is still that distinction. Does that help, or does...
It does. So the main difference between having a shared parenting order, which is what most people should aspire to,
right,
is you have more choices in the legal matters like the schools and the doctors. But if you just have an access visitation order, then you can't say my child can't go to that school, or you don't have those decisions
right.
to make. So.
Yeah, if you have concerns about their education, you're going to have a harder time when you want to go to the school and say, can I please have their attendance records and their report cards, and then if they do turn them over, then if you want to have a meeting with the teacher to discuss any issues that may arise, you're going to have a harder time doing that without shared parenting. And yes, everyone should aspire to have shared parenting.
How easy, or should I say how difficult is it to get shared parenting in juvenile court?
I would say it's easier than not getting shared parenting. Well, it depends, actually. When dad goes when he initiates the case, and usually it is dad, that when he just goes and asks for custody and visitation, the mediator is going to push shared parenting.
The mediator's going to push shared parenting?
Yeah, as I explained before, okay. when you do the initial complaint and application, the first step is to go to mediation. The mediator is going to encourage shared parenting for both parties. Yeah. Because studies have shown that that's the best for the child.
Yes.
That the child does not have to feel as if he or she has to choose between one parent or the other, that parents are working together, toward a common goal of, raising their child to be a decent human being.
Right.
So if it doesn't work out in mediation, then the magistrates will also then usually explain that, and it's not, you have statutory burdens, and it's not a statutory burden is that a burden of proof. Okay. For example, the most commonly recognized one is the proof beyond a reasonable doubt for a criminal case, for example. Right, yeah, okay, it's different with custody cases. There has to, it's very vague, but change in circumstances, significant change in circumstances. If you want to change something about your custodial arrangement, but like I said, with the initial application, shared parenting is easy to get. What I was talking about with the burden is that what I've seen is that although it's not in the law that mom has to show why there shouldn't be shared parenting, that's sort of the way it is in practice. If she doesn't want shared parenting, she has to explain why. Why shouldn't dad have equal rights as her? So to answer your question, it's easier than not getting a shared parenting. Now, that's with initially. If you agree to something less than shared parenting, changing it down the line is very, very, very difficult.
Is it?
Very difficult. So I would encourage people to get what they want or close to it within reason, of course, when they do the initial parental, whatever the arrangement they're going to make with the other parent.
Okay, thanks for that. What advice would you give fathers of children born out of wedlock in this state? I mean, we kind of already talked about that, but...
Go to court. Definitely
get your
go to
parental
court.
rights.
Yeah, go establish your parental rights.
And if they need help, they can call your office again at what's the number again?
440-409-0300.
And again, Bartos & Bartos comes highly recommended by me.
Thank you.
There's other attorneys in the office, David Bartos, and I'm not sure who else is there now.
David and Daniel are brothers. They're Bartos and Bartos. They're the two partners. We also have another attorney, William Doherty, who also works in juvenile court quite a bit. I think he's there pretty much every day. And then another attorney, Denise Demish. She doesn't do as much juvenile court work. She does do more of the domestic relations and civil litigation and adult criminal work, more so than the rest of us do. But yeah,
so you guys can cover a bunch of stuff.
Yes.
Yeah. What is your favorite court, domestic or juvenile?
I'm the most familiar with juvenile court. However, domestic relations is a nice break from juvenile court.
I totally agree with you. Totally agree with that. So it's two different entities. They're so different. Even when you walk in, the atmosphere is different in both courts.
Completely different. It's a lot more professional in domestic relations, which is something I appreciate.
Right.
But it's so different. I mean, and essentially, you're talking about the same process, except in juvenile court, you take the marriage which is basically property, out of the process.
Right.
And for being so similar, the two courts are so different. Yeah.
I agree to that. I had a question from one of my old clients who believes that there's parental alienation going on in her case. Can you speak anything about parental alienation and how the courts are viewing it? Are they viewing it? Do they take it into consideration?
It's not. They consider it if someone makes the allegation, but it's taken with a grain of salt because.
So if a client would say, I believe the other parent is it's parental alienation, which means that they're telling this child bad things about the other parent.
Right.
So they can say, I believe the other parent is saying bad things.
Yeah. It would be that person making the allegation. It would be their burden to show.
To prove.
That is actually true and that's actually going on. And they would need an expert, a mental health expert, to say that yes, in fact, this is going on with this child in this case.
Really? Well, that's I never heard of that, so that's good. So
yeah, you would need. I mean, so if you
would obviously go to trial.
Yes, you could go to trial.
But if you had an expert, see, I'm not an attorney, so I don't know the exact system. Can you bring in an expert to testify without going to trial, or would the expert have to testify in trial.
Trial. You would need it in trial. Yeah.
Okay,
However,
so they
you
couldn't just write a letter and say, "Dear Judge, I believe this is going on."
Right. Well, you could submit that. The best way to get it into court, or at least in our court, would be to make the allegation and have the diagnostic clinic do an evaluation. And they do submit a report before trial. And you typically will at least have one final pretrial after the report goes to the judge or magistrate, and the judge or magistrate has read it. So if someone suspects parental alienation, absolutely you can say so. You would need to prove it, and like I said, it's taken with a grain of salt, because a lot of parents will have a hard time understanding that although their child doesn't necessarily want to be with them, or doesn't want to be with them, or doesn't want to spend time with them, it may be partially their own fault.
That brings us to another question. That's not on the list, so
Okay.
if you don't want to answer it, don't. But let's talk about that. Let's talk about if a child is 14 and refuses to go to the other parent. Say the custodial parent obviously can get a motion to show cause filed against them, right?
Yes.
But what if the child is still adamant, I won't go, I won't go? What can be done in that situation?
For which parent? The parent that...
Say the custodial parent has a child, the child does not want to go visit the non-custodial parent because for whatever reason.
Okay. There's a couple of ways to it. I actually had a case where the issue is that all the children refused to go to see their dad. And what ended up happening with that case, the non-custodial parent, the custodial parent under shared parenting, and it's actually in the law, they're required to encourage the child or children to go see the non-custodial parent, okay, or the non-residential parent in shared parenting. That requirement or the duty to encourage a child isn't necessarily there if there's not shared parenting, but it's sort of presumed that you really should encourage your children to have a relationship with the other parent. So the court will first say, well, you need to make them go. It is a court order.
What if they
absolutely refuse?
Mm-hmm.
What will usually happen is they want to know why. Okay, if the refusal is based on domestic violence, negligence in any way on the parent's part, if like the parent is, leaving the child at home alone or with an older sibling, they're going to want to know why the kid doesn't want to go, and they'll find that out typically through a guardian ad litem. And the guardian ad litem will do an investigation. In my case, the kids had counselors that knew what was going on, and they were able to relay that information to the guardian ad litem, who then, gave it to the court. Eventually, what happened in that case is that the guardian ad litem did observe some supervised visitation with dad, and saw that there was a lot of animosity between the father and the children. He stopped the visits altogether and said the only way we're really going to be able to do this is that if dad and kids actually go to counseling together to work out the issues that are causing this tension so much so. And there was a 17-year-old child that the magistrate was like, well, we're not going to really be able to force her to do anything. So,
right.
If they're older, then they're saying the court, I don't want to say for sure, it just depends. Everything depends on this particular situation. But the court will take their hands off of it a little bit and say, well, what's done is done usually, and there's something much deeper going on in this relationship that forced visitation or forced supervised visitation is not going to resolve.
Do they ever order divorced couples or never married couples into counseling together, like the mom, dad, and child?
They will order them to do parenting classes. Yeah,
together.
Absolutely. I've never seen them order parenting classes together, but I've seen them order parenting classes that are geared toward trying to help parents parent together but separately, and help to understand how different it is when you are not in the home of the other parent and can't control every aspect of your child's life when they're not with you. But they could, like we talked about before, they could order that if they wanted to.
They can order anything they want. Depends on what
then
magistrate you
get. Then they can order who pays for it too.
Right, exactly.
Yeah.
We had one more question that we talked a little bit about. Remember I was talking to you about the gentleman whose mom, the baby mom left the state, took the kids with her. The gentleman has no address to contact the children, contact the mother, change his custody order. He's paying child support, and he's perplexed. Mm-hmm. What advice can we give him? Besides, I'm sure it's call a lawyer, because like we talked about, it's a very difficult situation. Mm-hmm. So his best bet would to be call a lawyer and maybe hire a lawyer to help him with this case. But is there anything you can tell our listeners, anything they can do on their own to alleviate?
Well, if there is an order for visitation or custody in place with the court, their first step would be to go file what's called a motion to show cause. You mentioned that before. For the people that don't know what that is, it's that you are asking the court to find the other person in contempt of court for not complying with the previous court order. If she's taken off with the kids and that she won't disclose her address or her whereabouts, I'd be willing to bet that that's in contempt of a court order. She probably needs to let him know of any change of address. And obviously, if he has visitation, then she should be making the children available for visitation. So that would be the first thing to do.
And that might be easier for him to hire a lawyer and go this route instead of maybe hiring a private investigator to find her address. Because I think we were talking in the hallway about, what did you say you can do in that case? Subpoena Cecil's records?
Yes, in order to get her address. If he's paying child support and she's receiving it, it's going somewhere.
Right.
Now, it could be being deposited in a bank account, and that might not be helpful, but that would be one step that could be taken, absolutely.
Because I would say 4 years ago, I would just be able to call child support and ask for mom's address. Mm-hmm. And they say, oh, no. What is it, HIPAA law now?
Yeah.
Because they put in the cash medical, that's when that changed.
Mm-hmm.
It became under HIPAA law, and they're like, no, sorry, we can't give out addresses.
Right.
So I was stumped on that. I don't know what to tell people about that besides call a lawyer.
Yeah.
I think that was all our questions for today. Is there anything you'd like to throw in about maybe your experiences working in juvenile court with the parents?
Like we talked about before with dads, it's important that they go establish their rights. More importantly, however, is that if they're doing so and they have a relationship with the mother, whether it's they've maintained their romantic relationship or they're just on civil terms, be upfront and honest about what you're going to do and what you're seeking. Oftentimes when mom gets that application or that complaint, they think he's trying to take my child away from me.
Yeah, I have that all the time. I really wish that juvenile court would change the caption on their form from custody visitation to because you're right, the mothers freak out when they get those thinking father's going to take custody, when in all actuality most of the time they just want access to their child.
Right, or they just want in writing what they're already practicing. Right. So, like I was a GIL on one case, for example, where dad filed, didn't let mom know. He's a professional, a career military person. And he needed shared parenting in order to be able to provide their daughter benefits.
Really?
For the military, apparently. And he didn't want to change anything that they had arranged. He just needed some parental rights in order to provide her with medical and college tuition benefit, all kinds of stuff that would only benefit her. But he didn't tell mom that he was doing it. And so it took her a little while to calm down and say, okay, well, this is really something good. And this needs to happen. But our justice system, including areas of domestic relations and family law, is adversarial by nature. So once you get into court, people want to battle. And I would suggest try, if you can be open about what you're trying to do when you're going to court.
Number one more time to our listeners.
Okay. It's 440-409-0300.
Thanks, Jessica.
Thank you.
So that's it for today's show. If you want to call our offices, we're an family advocacy group. You can reach me at area code 216-227-9111. If you need more than an advocate, I know lots of great attorneys in the Cleveland area. I will hook you up with a great attorney. Thanks for watching.